to our brown bag beat bite session for today. I'm going to tell you a little bit of a story to kind of set the mood and introduce our speakers. A long time ago, well, last week anyway, in a galaxy not so far away, with bases in Plymouth and Mount Clemens, and through a strategic alliance with Fraser-Trebilcock's satellite locations in Detroit, Lansing, and Grand Rapids, we begin. Episode 4, or 1, depending on how old you are, starts out. It is a period of civil war between the smokers and non-smokers, the pet owners and the quiet seekers, those in favor of chocolate brown trim and those that prefer tan over everything else. Whatever shall be done. But the board of directors has managed to find a secret ally in the attorneys of Zelmansky, Danner, and Fiorito. And now, here we are to present Amending Your Documents in 2020 and Beyond, featuring Tracy Danner Bond, our general organa, and a partner out of our main base in Plymouth, Richard L. Wagner, Jr., our Obi-Wan Kenobi, and a senior associate at our base out of Mount Clemens. Your host today on Zoom is our very own Padme, Associate Attorney Melissa Francis out of our Plymouth base, and me, I'm definitely the Wookiee, Stacia Miller out of our Mount Clemens base, hosting you on Facebook Live today. Prepare yourselves for an interactive battle brief to resolve this civil war. Without further ado, beam me up, Scotty. Oh no, that's the wrong series. I am just a Wookiee after all. May I present Padme.
Good afternoon, everyone. I will be, as Stacia said, your host on Zoom, and she will be your host on Facebook. Just a few housekeeping things. If you are on Zoom, please keep yourself muted and your video off throughout the presentation. I will be moderating and taking questions in the chat on Zoom. So if you open up your chat box, you can type in there any questions you have, and then I will ask the presenters. Stacia will be moderating on Facebook, so if you have questions, just drop it in the comments, and she will ask the presenters. So, without further ado, we present to you Amending Your Condominium and Homeowners Association Documents for 2020 and Beyond. Tracy, take it away.
Good afternoon, everyone. Thank you for joining us. Today's topic, as both Stacia and Melissa have mentioned, is amending your documents. And Richard and I are going to be tag teaming this presentation. I will be focusing on amending your documents for condominium associations, and Richard's focus will be on amending documents for homeowners associations. So let's go through and identify what documents a condominium association will have. First up is the Articles of Incorporation that establish the association as a nonprofit corporation. Your master deed consists of the master deed itself plus 2 exhibits. Exhibit A is the condominium bylaws, and Exhibit B is the condominium site plan. The condominium documents also include association or corporate bylaws if you have that as a separate document. And often associations will also have rules and regulations as a separate document. Generally speaking, the association or corporate bylaws are not recorded, which causes some problems. And the rules and regulations are not recorded. However, the master deed with its exhibits are recorded with the County Register of Deeds where the property is located, and the Articles of Incorporation are filed with the state of Michigan. Richard, what are the Homeowners Association documents?
I too would like to welcome everybody to our presentation, and thank you for giving us the opportunity to enlighten you on these matters. The Homeowners Association is somewhat different in terms of, but somewhat similar. It has, instead of the master deed, it has a declaration of covenants and restrictions. Sometimes it's called covenants, easements, and restrictions. And it has association or corporate bylaws, which are typically not recorded in contrast to the declaration. The Articles of Incorporation for the nonprofit corporation, and rules and regulations. And a couple of other things to point out is that there's also a subdivision plan, just like the Exhibit B in the master deed, although we didn't put it on the principal slide because a lot of times there's not so much focus on the subplan, but you'll learn as we go through the rest of this presentation that sometimes a subdivision plan is very important. Also, you may typically have some easement agreements, which may or may not be recorded, but are reflected in the written documents. So we're going to talk a little bit about that too, right? But basically, it's almost a similar format to the condominiums, but a little bit different. Right. Next slide.
We have many goals that the firm focuses on with amendment projects. And the first goal that we want to talk about is tidying up your documents. This is where we have the opportunity to remove all the language and the documents related to the developer and its rights and responsibilities. If we still identify who the developer was for continuity purposes, but all of the developer's rights and responsibilities will then be turned over to the association. This is our opportunity to correct grammar, punctuation, spelling. I take an opportunity to put in gender neutral identifiers so that we're not doing the his, her anymore, recognizing the changes in society. Also correcting any labeling errors, definitely adding a lot more headings and subheadings. One thing that we add is table of contents for the master deed and the bylaws. So that's easier to find the topic that you are looking for within that document. Also, we're going to remove or correct any illegal or potentially illegal provisions, and Richard is going to go into more detail on that in a minute. Also, we want to update any insurance terminology. Over time, the insurance terms have changed a bit. So we want to make sure that your documents reflect what type of insurance your association has. And there are just some technical changes that need to be made to your document so that the documents comply with current laws. So Richard, what illegal or potentially illegal provisions have we seen that we need to work with?
Thank you, Tracy. Frequently, you're going to see in either the declaration or sometimes in the bylaws, which do talk about certain kinds of restrictions, although they usually focus on the operation of the corporation. But there might be provisions that talk about the board has final approval of the renters in the community. This is looked on with disfavor by the secondary mortgage market and the federal institutions that issue mortgages. Any definition of a family purpose, you have to be very careful about how you state what is to be the purpose in terms of residency in the community. It is certainly a problem if you say that children under the age of such and such are not permitted, and you'll notice that a couple of lines down, unless you have what's called a HOPA type of community, which is a Housing for Older Persons Act that was passed by signed by President Clinton in 1995. And this allows you to have certain restrictions as to children in the community. However, there's a number of significant regulations that you need to comply with in order to maintain that status of HOPA. Otherwise, if you have any kind of restrictions with reference to occupancy by minors, or you try to limit it to married people without recognizing that there are other forms of relationships, you're probably going to run into some problems with the people from the civil rights. Restrictions that talk about size and breeds for dogs and that, those are also disfavored because of the fact a small 3-pound dog like I have is just as much a nuisance as a big 50-pound dog. So there doesn't seem to always be any rhyme or reason to those restrictions, and the courts have frequently struck those down. However, there is an argument, and it's been raised before, that sometimes insurance companies will withhold insurance coverages if you do allow certain what's considered vicious animals in the community. So any provisions that address the denial of sales or rentals that are premised on any one of the protected 10 classes, such as race, religion, gender identity, and so forth, those are always looked at very suspect, and you need to be sure that your documents do not violate any of those types of civil rights considerations. And you also want to probably get rid of any provisions that address the association's right of first refusal, particularly in sales circumstances. One of the things about that is normally in the secondary market, when you're looking for mortgages, if the association has the right of first refusal, it makes it very difficult to get mortgage lending. So And one of the other things that I happened to think about last night in my dreams on this seminar was the fact that frequently associations may pass amendments that are not particularly in compliance with the requirements for how to do amendments in their community. As such, those would be considered illegal amendments. So we're gonna talk a little bit later on what you can do with that kind of for a remedy for that. So with that, on to the next page. I think we are.
Goal number 2, improve functionality. And again, my focus is going to be on the condominium associations. So to improve the functionality of the Articles of Incorporation, we want to update provisions to protect those volunteer board members, officers, and other committee members, clarify the board members' responsibilities, and also update the indemnification language that is reflected in the 2015 amendments to the Michigan Nonprofit Corporation Act. With respect to the master deed, we found that the definition sections are always too short. We want to define terms frequently seen in the documents, both within the master deed and the bylaws, to make sure that people understand exactly what they mean. We also want to clarify and expand the list of common elements. We often find inconsistencies between the master deed, bylaws, and condominium site plan with respect to common elements. We want to make sure that all of the common elements are properly identified. We also want to clarify and give more detail to the responsibilities for those common elements. And I found that the best way to deal with those responsibilities is to break them down into 3 categories. Those common elements that are purely the association's responsibility to maintain, repair, decorate, and replace. Those that are purely the co-owner's responsibility. And then there are some that there's shared responsibility for common elements. And a good example of that would be doors. Maybe the co-owners are responsible for replacing your front door, but the association is responsible for painting. So that's where we address specific responsibilities, and we find that current documents just don't provide enough detail. So we want to make sure that co-owners can pull out those documents, look at the table of contents, find that common element they're wondering about, and they can figure out very easily who needs to maintain that. With respect to the bylaws, we want to make sure that those bylaws mirror the master deed with respect to the common element responsibility section. We want to remove any inconsistencies. This is where we're going to address hot topics, and we'll talk about hot topics a little bit later, but what I'm referring to is rental restrictions, changing insurance coverage, changing maintenance responsibility. Those are hot topics that we've found that we need to treat a little bit differently than some of the others. We also want to add more detail regarding restrictions. We want to make sure that that restriction section in Article 6 mirrors what the association has been doing in the past. And also fine policies. Maybe those fine sections within the bylaws aren't adequate, don't have enough information. That's when we have the opportunity to improve that section. And if you've got association or corporate bylaws separate from your condominium bylaws, this is when we're going to combine those provisions so that you have one document that is recorded with the Register of Deeds so that it's public record and there's no question on how that association is run. And finally, we're going to add different topics that have become relevant in the 21st century, and we're going to focus on that a little bit later. Condominium site plans generally aren't revised in amendment projects. However, if there's been changes in unit boundaries, we need to update those drawings to identify that. Sometimes common elements aren't identified properly in those plans, so we need to have those added as well. And we, again, want to make sure that the common elements that are on the site plan match the common elements that are identified in the master deed. Richard, what do we need to do in homeowners associations to improve functionality?
Hey, as like goal number 1 for condominiums, and you certainly want to reflect on those improvements or goals, excuse me, for purposes of the homeowner association. Likewise, goal number 2 is going to address a lot of the issues that Tracy's referenced with reference to condominiums. With reference to the articles, you want to clarify what the board members are supposed to do and not supposed to do. Make sure that they are not responsible to do something that's not identified in the community documents. Frequently, you will have membership who indicates, well, you're on the board, you need to take care of this problem. Well, there's some things that the board really doesn't have the power or the authority to do. So you want to make sure that the articles of incorporation, the powers are envisioned in the articles in terms of what the board is going to do. You also, with reference to the declaration, and this is really important because the declaration of covenants and restrictions, rather than talking about common elements, you're talking about common areas. And frequently, you're going to see a lot of language in the declaration that you may not have sufficient information about, and you may not have sufficient information on how to deal with it. So for the question is, you need to make sure you define all common areas. Are there, and there's about 8 different things you need to look for. One is, are there any landscape or easement agreements that were signed up by the developer with the municipality? Are there any shared expense easement agreements with sub number 2 that's behind you? Are there any natural area protections or dedications that involve the state of Michigan? Are there floodplain easements? Are there retention or detention pond easements? What's the responsibilities with reference to the association in regard to that? Are there public or municipal utility easements? And is there any responsibility or exposure to liability on the part of the association for that? Are there any state or county or local drains or other forms of easements? And are there any negative reciprocal easements with reference to other associations? Do you have amenities that aren't addressed? I had one association that had tennis courts and there wasn't even anything in the documents with reference to the tennis courts, so on and so forth. So you want to make sure that your declaration identifies everything that's in your community. And if it references an agreement, by all means, get your hands on that agreement, discuss it with your attorney in terms of what you need to do to amend your documents for any responsibilities that you have in that. Be sure to check your plat. All right, this is where the plat does come in. It's important. Sometimes it may have a reference to a landscape agreement or an easement agreement. It may not be in the written declaration, but it's on the plat. It's going to make you just as responsible as if it was in the declaration. Okay? So our reference with the bylaws, you want to make sure that they parallel the responsibilities and restrictions that's in the declaration. You don't want anything contrary in the bylaws to what's in the declaration. But on the other hand, do the bylaws appropriately address, like was mentioned in the previous slide, they address voting procedures, recovery of attorney's fees for writing letters, not just having a proceedings. Frequently the documents will say in the event of proceedings, you can get your attorney's fees, but what if you want to send out a letter about a stray dog? Are you entitled to recover attorney's fees and costs and expenses for that? It's also extremely important, as Tracy's already mentioned with condominiums, the definitions. A lot of times there's maybe 6 or 7 definitions that are either in the declaration or the bylaws, or 5 in the declaration and 7 in the bylaws. You want to make sure that you expand those topics so that you have a definition. Define what is default, what is, who is qualified as an eligible voter, what kind of circumstances can create or pertain to nuisance situations, so that the association does have the authority to step in when it needs to because of the fact that there's a problem in the community, or also address the circumstances when there's, heaven forbid, some kind of disaster or perhaps a domestic situation where the homeowners are not properly taking care of their property or doing something about the problems that exist with their dwelling or their outbuildings in the subdivision. You certainly don't want to enter the subdivision and see the first dwelling, a burned out dwelling, sitting there in the corner for 2 or 3 months. So it's very important that you do amend your documents in all of these areas to talk about all these types of considerations. So, Tracy, from there.
Okay, now we're going to get into those hot topics. We've identified several topics that could potentially kill an amendment project. And what I mean by that is, if someone feels very strongly about the proposed amended documents with respect to no smoking in the unit or common elements or anywhere in the community, they're going to vote no on this project. So these areas that we've identified are just some of those topics that the board needs to have a good understanding of how the community feels about them. If the board wants to institute a smoking ban within units, the board better understand how the community feels about that, because you need to have the support of the owners in order to pass that specific ban. So the areas that we've identified as potential hot topics are rental restrictions, smoking, shifting maintenance responsibilities, changing insurance coverage that's provided by the association. We recommend that the board of directors get a sense from the community how they feel about potential changes in these topics. If it's divided, even 50-50, we recommend possibly doing a survey, especially with smoking. I would not move forward with a proposed ban on smoking before you send out a survey or take the pulse of your community regarding how they feel about a smoking ban. So you can do surveys within the middle of an amendment project to see how the co-owners and owners feel about that. The other way we can deal with hot topics is actually pull them out as a separate topic to vote on. And we're going to go into a little more detail about that in the voting section of this presentation. But these are areas that we definitely need to focus on and talk to the owners about at that informational meeting that we will also be going into more detail. But these are the hot topics that our firm has run into and pulled out and identified as areas that really need to be focused on.
Tracy, I have a few questions.
Yes.
From our audience. The first question, and I will address it to Richard, is in an HOA, can short-term rentals like Airbnb and VBRO be restricted as part of the amendments?
It's my considered opinion, it can. These are covenants that are running with the land. And so long as that you amend your documents and have the appropriate methodology and the numerical number required for approval, then you can. There are a number of unpublished, as of yet, Court of Appeals opinions that address the fact that these types of operations are in fact a commercial enterprise and not residential, primarily because of the fact they're of short-term duration. So frequently what you want to do is amend your documents to make sure that you identify that you are a private residential community, no commercial operations. And in some instances, and in one instance, I had to put in the fact of no industrial operations, as a gentleman was trying to operate a welding business on the side in his garage. And ironically enough, he was utilizing some of the utility services provided by the association. So you have to examine what's going on in your community and make sure that that is addressed in your amendments. But definitely, I believe if you get sufficient vote and you follow the proper amendment procedures, there is no reason why you could not restrict that. Now, note, this is like B&B and short-term rentals as opposed to other types of uses like, daycares and so on and so forth. That's a whole different kind of topic we'd have to talk about.
And Richard, if an HOA owns the roads within the subdivision and they have an additional document related to the roads, should they include the terms of that additional document into their covenants and restrictions when they do the amendment project, or should it remain a separate document?
Usually what I do with a lot of those types of agreements is I'll attach them as an exhibit. So you're not running around looking for different documents. So when I re-record the declaration, I'll have the bylaws, which typically bylaws are not recorded for homeowners association. I'll record for the bylaws perhaps as exhibit A. I'll make sure that the subdivision plan is exhibit B, kind of parallel to what happens with condominiums. I will have easement agreements or road maintenance agreements or shared expense agreements and go on, so forth and so forth and so forth. So you don't have to hunt and peck through the register of deeds to find out what you need to comply with. You can just sit down and look at one document, just like Tracy does with the condominiums, or first, second, third, fourth amendment, or consolidating master deed or whatever. We put them all into one basket and you just have one binder with all your documents, including your rules and regulations.
And Tracy, If your city or township has restrictions on dog breeds that can be kept within the city or the township, can you list those specific breeds in your amendment project in your bylaws to be prohibited?
You could, but I would not recommend that because it's very likely that that municipality could change its ordinance. So what I would do is simply reference that the association has to follow any local ordinances with respect to pets. So that would be identified in the pet section of Article 6 in the restrictions.
Thank you. All right, now we're going to move to other hot topics for the 21st century.
Oh, yes. Okay, these are things that have come up, and this is by no means a total list of all the things that are happening in the 21st century. But addressing things like alternative power sources, solar, wind, generators. Up where I am in St. Clair County, we frequently lose power, and as a consequence, sometimes your generators all over the place. And it can become quite a nuisance in the community. So you might want to do something in terms of addressing these. Drones, it's here, it's coming. I don't know if you're pizza delivery, but you do have some authority until the federal government takes complete regulation on. But you certainly have authority to make sure that drones are not a nuisance or create a bad circumstance in your community. Addressing electrical vehicles, charging stations, and so forth. The operation of autonomous vehicles. I know some communities that don't want driverless vehicles in their community because of the fact they have so many children and so forth. Certainly addressing emergency plans and powers, and we'll talk about that a little bit later with reference to the current COVID situation. But you want to make sure that there's always some type of provision that allows the board to operate in the case of a national state emergency or some catastrophic circumstance. Absolutely, you have to address fair housing and discrimination concerns. Do your documents talk about civility provisions? You have to make sure that your documents reflect that the community has policies and procedures that are against discrimination and against the lack of civility. One of the first things you get with a letter from downtown or wherever from the Michigan Department of Civil Rights indicates, okay, what kind of policies and procedures do you have in place with reference to these types of allegations? So you want to make it clear at the outset, and it's recorded and carved in stone, that it is the policy of your association that you do not tolerate those types of circumstances. Multimedia installations. If you're going to be using multimedia resources for your publication of your minutes or your meetings and different things, you want to make sure that there's some type of protection for the privacy rights of your members and that. So it's very important to make sure you have procedures in place on that. Parking, that is probably one of the biggest things in, you've heard the phrase before, parking pets and people, and parking is really big in subdivisions. It's real nice to have a nice laid out cul-de-sac subdivision, and you've got a circle of 4 houses and you got 12 cars. All right, and it becomes an actual living nightmare for the people that live there. So sometimes you have to make sure you consult with your attorney about what type of remedies you have available to address these types of certain circumstances. Website concerns, again, you want to make sure that you have something in language in your documents to address websites, what you're going to do. One of the things that's also very big right now, and probably most of you that's got any familiarity with what's going on with the legal system, is alternative forms of dispute resolution. So sometimes you may want an arbitration provision, but you certainly may want to consider an alternative form of dispute resolution, because candidly, when you go to court, you're going to get sent, you're going to be asked to find a mediator, a person who can resolve your problem, or go out and come back, go out and come back. That's why litigation is so expensive, because it takes so long. So if you've got something already in place, perhaps if you sat down and talked with somebody and a third party who's experienced this type of circumstance, you'll be able to get it resolved without having to go to the extraordinary expense of going to court. So these are just a few of the things that we talk about, and there's probably about 50 or 60 different topics that I have that I bring up with my boards when I say hey, what about this? If it fits or applies, fine. If not, well, we'll think about it later. It's certainly good to have something in place now because you know some of this stuff is coming eventually. Solar's coming to Michigan sooner or later, and you don't want somebody putting up an array of 150 solar, whatever those devices are, across the whole front yard or backyard.
Richard, one of our viewers says, our management company alerted us that they are going to be heightening restrictions on comfort animals. The owner will now have to have appropriate sign off from a medical professional that in fact their animal is a comfort animal. Can you comment? This would allow us to make note of this in the bylaws. So I believe what they're referring to is the proposed Michigan law.
Right, and this is one of my favorite topics. I had a couple of seminars on this already. The emotional support companion animals and the service animals, which there's only two. The emotional support companion animals, and thank goodness the Department of HUD in January of 2020 finally gave us a little more instruction in terms of what we can and can't do. I frequently put in all my documents talking about animals because, as you might be aware, emotional support animals are not pets. So you don't call it a pets provision because it doesn't do you any good because they're not pets. So you call it an animals provision, and you may have pets in there, and you may have service animals in there, and you may have emotional support companion animals. It's extremely critical to make sure that once you become aware of it, and there doesn't have to be an exact written request for it, it can be you become aware of it through word of mouth, or someone has mentioned it, or someone's come in, or frequently what will happen is you send out a letter, your management does, saying, you have a pet, they're not allowed. They'll send back, well, it's my emotional support. Okay, now it's time for you to start what's called the interactive process. The interactive process is a series of investigations where you can now make a request that a health professional identify the fact that, number one, the person is qualified as a person with disability. Number two, they have a need for this animal because it helps alleviate the symptoms of the incapacity of whatever the disability is. You don't have to get into the nature of the extent, and nor do they have to disclose the nature of the disability, but they need a health professional to say that this particular animal will help alleviate it, and it is appropriate for that circumstance. You don't want to go to a foot doctor for a dog that tells you when to take your pills and get a letter from them. I mean, you've got to have a health professional. It's got to be someone that has been treating and seeing the person, basically not somebody that you sent away $29 over the internet. So you want to make sure that you investigate that. And it's got to be a circumstance that going to last longer than 6 months. So there are a number of procedures. Certainly, I highly recommend that you get a hold of your attorney as soon as possible, because it is possible to deny emotional support animals if, in fact, that they fail to participate in the investigative process, the interactive process. That answer the question, or is that too much?
Yep. No, thank you, Richard. Tracy.
I love animals.
How do we make our documents comply with state and local law?
We need to make sure that we include provisions that address Federal Fair Housing Act and Michigan Persons with Disabilities Civil Rights Act issues. Those are some of the circumstances that Richard just talked about with the emotional and companion support animals, service animals. We want to make sure that we don't have any potential discriminatory language with respect to the definition of family that we already talked about. This is a good part where we have to look at the local municipality ordinances and see if there's anything that conflicts with the local ordinances. Michigan Condominium Act, we want to make sure that everything conforms with that, as well as the Michigan Nonprofit Corporation Act. We want to take advantage of those, especially with condominium associations. We want to make sure that we're taking advantage of the protections that are offered to associations, especially with the Michigan Condominium Act and the Nonprofit Corporation Act. With respect to electronic voting and remote meetings, that's been a big thing right now with the pandemic going on. So we also want to make sure that we're complying with the Michigan Revised Judicature Act, which deals with foreclosure of mortgages and land contracts. Richard, what local, state, and federal laws are we looking at for HOAs?
Well, we're going to be looking at a lot of the same acts that you've just mentioned, the Federal Fair Housing Act, as we just talked about with emotional support animals. and acts of civility and discrimination, and that you want to make sure that your documents indicate the fact that you don't tolerate that circumstance. In the old days, it used to be you could say, oh, it's a neighbor fight, don't get involved in that. You can't do that anymore as of October of 2015 with federal law and so forth. Michigan Persons with Disabilities Civil Rights Act is an extremely extensive multi-article provision that talks about the rights of persons with disabilities in terms of acquisition to housing, employment, and so forth. So you want to make sure that in all instances you cover all the circumstances to make sure there's compliance there. The Revised Judicature Act is the same thing that applies when you want to try to foreclose on your assessments, whatever they're called, maintenance assessments or carrying assessments or whatever they're called for purposes of supporting the expenses in the association. Likewise, the Michigan Nonprofit Corporation Act is important to make sure you comply with the major changes in the act that occurred in 2015 and expand the rights and remedies and protections, as Tracy's mentioned, with reference to your nonprofit association. Are there any local, county, city, or township ordinances for which you must be in compliance with? And frequently, this is, again, interaction with those kind of agreements that you didn't even know you had with reference with the municipality, that the developer went to the city and say, hey, I want to put this sub in, what do I got to do? And the city graciously accepts to approve his subdivision, provided he enters into all these different agreements. So you got to make sure that you're aware of that. I saved kind of the best for last, the Michigan Marketable Title Act, which is the title companies got together and said, listen, we got to get this straight. Anything over 40 years is gone. There's not going to be any more restrictions. So sorry about that. So it's eliminated there, okay, unless you do something to reassert or reestablish your covenants. Now, fortunately enough, they decided, the legislature in their infinite wisdom decided to exempt condominiums a couple of years ago, and they did that by amendment. However, unfortunately, they did not do that for subdivisions. There's been attempts to do it, but it hasn't happened yet. And as a consequence, there's a lot of subdivisions that are over 40 years old, and they're saying, well, sorry, your restrictions are no longer applicable unless you go through this extensive procedure, file affidavits, and so on and so forth. So what we do when we amend the documents, we say, we do hereby reassert, reallege, yada, yada, all the covenants, restrictions, and conditions that were in our original documents till the end of time, more or less. So we make sure that we cover that. There could be other statutes that apply, but I think most of them in Southeast Michigan, we don't have that, but there's statutes that apply, for example of, resort associations and so on and so forth. So if you've got a nonprofit association for that, you want to make sure you consult with your attorney in terms of what other restrictions or requirements are required for compliance for those other state laws. Okay. So
Goal number 4 is improved marketability. This is very important. You want to make sure that your documents are easy to read, understandable. You shouldn't have to consult with your attorney every time you want to try and read your documents and understand what they mean. So you want to take out that legalese whenever we can. We want to make sure that the documents are better organized and more concise. Again, we talked about adding headings and subheadings. That table of contents is going to be very important for the bylaws and the master deed. Incorporating all those prior amendments. I have a couple associations where they've amended their documents 14 different times, 9 times, 8 times. So every time I took a look at those documents to see what they said about a certain issue, I had to go back and say, okay, well, is this section amended by the 5th Amendment? This is the opportunity to take all those past amendments, incorporate them all into one document, keep everything together. Like Richard and I have both mentioned, we want to make it easy to find. One document is all you need to look at with respect to bylaws, the master deed or declaration, any other easement agreements, or anything related to that community. Again, we mentioned that the master deed and declaration of covenants is recorded with the Register of Deeds in the county where the property is located, and those articles of incorporation are filed with the state of Michigan. So what is goal number 5, Richard?
Goal number 5 is customizing your documents. Okay, one size does not fit all, and this probably applies in both types of communities, but it certainly applies in the homeowners association because of the fact that Most of the time, the developer changes the first page, last page, signs it, and he just wants to start getting building permits and selling. Most of what he's put in there has nothing to do with how you administer the affairs of your community, especially when he's gone, because he controls everything in terms of what you can put in there, what you can build, what you can do, and how to do it, and so on and so forth. So you want to make sure that your documents are amended for purposes of administering the affairs in your community, and as easy as possible in terms of, for example, trying to amend them. It's one of the things that I've talked with a lot of my homeowners associations is the declaration is usually the documents you want that are carved in stone. Absolutely X amount of square footage, X amount of exterior finish, X amount of setback requirements, and so on and so forth. And a lot of times it'll have certain restrictions in there or definitions in there. This might be the time when you're changing your documents that you go ahead and say, well, you know what? It's very hard to change the declaration. Typically, it requires a very high percentage, and we're going to talk about amendments later on and address that further. But it requires a very high percentage to change it because these are things you want carved in stone forever. So let's take and move some of these other things over into bylaws, because you could make your bylaws more easily amendable with a lesser percentage. You maybe need 70% or 100% for the declaration, but you could do it with 50 or 60% for the bylaws. Suppose time is what it'd be. In the old days, it used to be you couldn't have commercial vehicles. You couldn't have pickup trucks. That was a commercial vehicle. Well, now what? I don't know, 6 out of every 10 vehicles on the road is a pickup truck. So your documents are not consistent with the way the world goes around. So here's an opportunity for you to take and move some of these restrictions over to your bylaws for purposes of making it easier and more contemporary to what the situation is. It's also the opportunity, did you happen to pass any of those little amendments that did not comply with your amendment requirements? Those are facially invalid because they did not comply with the amendment requirements. So now if you decide that's what we want, well, we're going to put them in officially and we're going to comply, and we're going to make our illegal provisions now legal. Do you have sufficient definitions in your documents that talk about default or qualify to vote, as we've mentioned before? All right, so now is the time to fine tune your documents to match your existing practices, the desires and needs of the community, and be contemporaneous. Maybe you want to allow offenses that you didn't allow before. Maybe you want to allow, you're not allowed structures, but you want to allow a small shed for purposes of keeping rakes and shovels and so on and so forth. When these forms that they utilize for purposes of just building a subdivision, they don't have to live there. They don't have to think about what do we need to do to make life living easier in our community. So it's also important that all owners can and should be involved in the process. Like Tracy said, sometimes if you got something that, sheds are a controversy, above ground pools, in ground pools, whatever they are, that you've got people that want them, people that don't want them. Maybe this is time to get together and have some discussions or do a survey. Hey, what's the majority of the people in the community want? And then you can make your documents fit those types of circumstances rather than just spec and say, oh, no, it's in there. No, can't do it. Because then you end up with people that end up violating, and then you've got to decide whether you want to spend the money to try and stop them or not. And our job frequently is to try to keep you out of court. That way we want to make your documents fit with what it is that your community, the sentiments of your community is. And in that regard, then you don't have so many angry, rebellious people, the innies and the outies, so to speak. So that being said, next slide.
All right, so now what? We're going to talk about the amendment process roadmap that we use here at our firm. Step 1 is the attorney reviews all of your existing documents. This is where we have all the documents on our desk. What do we have? What do we need to work with? Then that attorney in step 2 prepares an initial draft of the amended documents for the board to review. That's going to be the biggest hurdle for the attorney as they're getting that first draft of documents, incorporating what the board has already told them that they want to change, just making all the changes to fit all the goals that we've already talked about. Once that initial packet goes to the board of directors, the board, and if they've got a community for the amendment project, The board and the committee is going to take a look at those documents and see what further changes they want to make. Then step 4 is taking those proposed amendments and sending them to all the owners for their review. So you've got to give those owners an opportunity to actually read the documents. One of the things that we do in our amendment project packets for the owners is to include a guide, because we recognize that these are tough documents to read. As much as we can make them easy to read, it's a lot to read, and it's not terribly exciting. So if all the owners do is read that guide is going to go through and identify the main changes that we're making to the documents, where those changes are, and to some extent why we're making those changes. So once the owners have a chance to review the documents, digest them, come up with some questions, then we have step 5, which is an informational meeting. This is the opportunity where the owners can give feedback to the board. There's no vote at this meeting. This is an open discussion. Generally, the attorney will give a presentation about the project, go through the documents one by one, go through the major changes, talk about those hot topics. So this is the opportunity where the board and the co-owners can have, or owners can have, that dialogue back and forth about why we're making the changes, why the existing documents don't work. Next slide, please. Step number 6 is the board is going to then take that feedback and finalize those proposed amendments with the attorney, and then send out that final amendment package and ballots to the owners. And the vote is, depending on what the documents for that community say, you may or may not need an actual meeting to vote on the proposed amendment project. So you need to follow your documents. Number 8 is for condominiums only. If you're making material changes to the condominium documents that require a mortgagee ballot under the Michigan Condominium Act, once the co-owners have voted to approve those amended documents, they need to be sent to the mortgagees for their vote. Unlike the co-owners must vote yes in order for it to be a yes vote. That's the opposite with the mortgage companies. If a mortgage company doesn't respond, that's not a no vote, it's considered a yes vote. So that vote is a little bit different. So that's a condominium only issue. And step 9 is after everyone has voted to approve those documents, then the attorney records the documents with the Register of Deeds or the state of Michigan, depending on what the document is. And step 10, final step, is getting those recorded or filed documents in the hands of the owner so that they have the most up-to-date documents for their files and for their review if they have any questions about what restrictions they have in their community. Richard?
Okay, one of the things I want to emphasize is from the former slide that Tracy mentioned, is the fact is that the attorney reviews all the documents. As I've said, a lot of subdivision, right now I'm dealing with a subdivision that was formed in 1928. And you try to get all the documents and make sure that you understand what's been happening in this community forever. So it's extremely important in all those steps that Tracy talked about, except for the ones that particularly talk about with reference to voting distinctions between condominiums and HOAs. But right now, the owner involvement is the key to a successful amendment project. And it's important for the board to take ownership of this and be leaders in this, because the owners only have a few opportunities to vote on certain association matters. They can elect the board of directors. They can vote on amendments to their association documents. They have additional and special assessments under limited circumstances, association loans. They have procedures in your documents that talk about doing that. A lot of times the provisions in homeowners associations understate or don't properly and sufficiently address the needs. As your subdivision gets older and you're responsible, like the earlier question that Mel brought up about private roads versus dedicated roads, you've got to deal with a situation where you've got collapsed roads or sewers that you got to replace, and you're, $250 a year or $500 a year, whatever it is for the homeowners, is not quite going to cover it. So you have to deal with making sure that you have sufficient provisions to be able to address those types of circumstances. and whether or not to pursue litigation depending on the provision. What I like to call them anyways, it's called poison pill provisions, where the developer puts something in there that it's going to take something just slightly short of an act of God for you to be able to go after your developer and file a lawsuit. They want to know who you're hiring as an attorney, how many cases he's had, how many children he has, how what success rate he's had, what he thinks is going to be the outcome, how much it's going to cost. All these types of provisions that prevent the association from operating as a corporation. And it's not just to go against the developer. It could be sometimes circumstances having a problem with a member in the community. You are limited that you can only file a lawsuit for collection of the assessments. And sometimes it says you can file a lawsuit for violation of restrictions, but if the restrictions aren't clear enough, it's going to be a question whether you can even pursue that litigation. So you want to make sure that your documents fit for the needs that you have to address. Owners want their voices heard. I know you only get 10 or 20 people that maybe show up at the annual meeting, unless you say you're going to raise the assessments 2,000%. But the bottom line is most people do care about their largest investment in their life, and that's their home. So they want to know what's happening in their association, in their community. So it's important for you to make sure that, as Tracy's pointed out, get the documents to them, maybe have meetings, have surveys, whatever it takes to make sure that you want a successful amendment project. Find out what the sentiment of the people are, because you need the owner support in order to get enough vote to approve the project. Let's face it, you spend all this money, you spend all this time in all those high-paying jobs that you have as board members in terms of trying to get this passed, and it's like, okay, well, we got 10 votes, period. What do you mean, period? Well, that's what happens. You've got to take an active role in this. And again, we can't overemphasize the fact that strongly consider utilizing the survey to determine how the owners feel about these amendments. How much control do you want to have over your members in your association? A man's home is his castle, that's fine. And as long as he takes care of it, that's fine. He or she takes care of it, that's fine. But the bottom line happens to be is if they don't, do you have the authority to step in and force compliance with the restrictions at as minimal expense as possible? Because you don't want a large part of your budget to be for chasing down non-compliant members who are supposed to all live happy together with us. That's my thoughts. All right, so next slides on the informational meeting for owners. Ms. Tracy.
Yes, let's go into a little more detail. I elaborated a little bit on what's going to happen at that informational meeting. As I mentioned, the attorney is going to give a presentation. Depending on your community, maybe a PowerPoint presentation is going to get your point across, maybe not. Maybe just sitting there and having a discussion about those documents is the best way to deal with the amendment informational meeting. But at that meeting, it's not just us as the attorney saying, here you go, here are these documents, you have to vote yes. The board needs to take ownership of this project. They've been working on this project just like we have as the attorneys. They need to take ownership of that project. They need to explain to the co-owners, look, this is our current documents are not working for us, and here's why. They're outdated, they don't address these common element issues, we're having water loss issues, and all of the costs are on the association, and we need to pass that on to the owners, and they need to explain what is going on and why it's not working. And then the attorneys can back up the board and provide the solutions for those problems. Here's where you're going to have the discussions about those hot topics, and welcome that discussion, because what the board might think the community wants might not be what they actually do want. And so this is where you really need to have an open mind and to listen and maybe compromise. Maybe the board needs to make some adjustments to those proposed amendments. That's why we have these meetings, because if you don't have the support of the owners, the project's not going to pass, and you have taken all that time and money, as Richard has mentioned, and now what do you do? So although we are going to talk about a failed project, we want to make sure that we do everything that we can to have that project succeed. So address those key areas of change, again, provide detailed explanation for those hot topics. If you're shifting responsibilities for maintenance, tell them why. Tell them, give them examples of what has happened that hasn't worked the best for the association. So take ownership, board members, and be open to what those owners have to say. And maybe if you're getting a lot of pushback on some issues, maybe now you kind of hit the pause button and take a survey. So you can do surveys at any time during this project. And if you find that you need to talk a little bit more, or give you some more time, or get some more feedback, you can push that pause button. Richard?
Okay, next we're going to talk about, aside after our funny slide, is the ways to vote on an amendment project. The customary practice and what we recommend, honestly, by the time you look at things, with so much has happened in the law in the last couple of years, let's say 5 years, historically, there hasn't been a whole lot of law. Original Condominium Act, and then, you know, the Deregulation Act, that's about it. And there's been proposed something for subdivisions just like condominiums, but it hasn't went through yet, and not likely to so far. So basically we're looking at documents that are either too old, they don't fit what's going on in your community, or they're a hodgepodge, or they don't identify everything that's in your community or who's responsible for what. So basically, usually by the time Tracy or I get through trying to track down all the documents and look at them, we're gonna say, you know what, we gotta sort of start from square one, okay? Unfortunately, and fortunately enough, we have a fixed price for that too. So there might be circumstances where you may want to have a separate vote on each change. I don't necessarily particularly recommend it unless it's a particular subject that you want to address separately. In the old days, and I mean back in the 70s, we used to have ballots that would go Article 1, Section 2, yes or no, Article 1, Section 3, yes or no, and that was just such a nightmare. But it's sometimes the people were so picky-unish, if you will, about what they wanted in the documents and not. So just, no. We're going to work together with the board, the committee, maybe some homeowners, and try to decide what we need for our community. So like Tracy says, you might have a hot topic. Well, this has come up, something about whether we want to allow in-ground pools or above-ground pools. So let's just think about an amendment with reference to that and identify that as a separate voting circumstance. That's fine. Something that's not, you know, it's out of the ordinary from what you have. But otherwise, you're doing a rewrite on the project, and you might as well do them all. You might as well do the articles, the declaration, and the bylaws. And you want to make sure, like I said too, the subplat is important for what's on it. And sometimes if the written doesn't match the plat, you need to change the written to make sure it matches the plat, or identify in the written where the plat doesn't match. So when you're making a hot topic changes, though, one vote can be taken on the entire amendment project except the hot topic. So we've, most of us, I think, have had experiences for that. A lot of times, the situation about leasing and leasing restrictions, especially after the crash of the 2008, a lot of communities became investment communities, so to speak, with the falling prices for real estate. And as a consequence, you end up with a very high percentage of non-owner occupied residences. And that can make life real difficult for an association as a whole and the individual members. So you may want to address those certain circumstances independently, or take them out until you can try to figure out a compromise on that type of situation. So that's the overall viewpoint on how to vote on the amendment project. Tracy?
The voting process definitely is different between a condominium association and a homeowners association. The Condominium Act states that amendments to the condominium documents, the master deed and bylaws, have to be passed by a vote of 2/3 of eligible voters. So the way that we do that is by mail-in ballots, meeting ballots, at the meeting, including proxies, and then we've got the separate mortgagee vote. But again, you have to look back to what your current documents state with respect to how to vote on an amendment project. Most documents will have a specific article that addresses amendments to the documents. So the master deed is going to have an amendment document section. The bylaws are going to have an amendment document section. So look to those sections of your current documents to see what the requirements are for voting. Most documents that I've seen will require a meeting, but it also allows mail-in ballots. So take a look at those existing documents and see what they say with respect to how to vote on the amendments. Richard, what do homeowners associations do for voting?
Well, we don't quite have it as easy as the condominiums do, because frequently they all say you need to have the signed written consent by X amount of percentage of owners. In the old days, when we used to have meetings, we'd be putting nickels in payphones trying to get people to come to the meeting and sign on the dotted line so we could attach the amendments. Or we'd be walking around with a clipboard to homeowner going, here, we need you to sign this to approve these amendments. That was very tedious and didn't always seem to work out. So basically now we do it on a ballot basis. And when we talk about having the signed written consent, when we do the resolution indicating that the amendment's been approved, we indicate that there's written consents on file with the association record. So that sort of takes care of that scenario, but it's still a very tedious process because you want to make sure you have sufficient ballots, sufficient enough to approve the amendment in accordance with the amendment provisions, which we're going to talk about that in a second. It's a very difficult process for homeowners associations. We do have one extra little special thing that says if we've got 250 lots or more, we can do it by electronic signature pursuant to the statute that's recited there. That does kind of help when you've got 300, 400, 500 lots communities, although, you know, the obvious problem is not everybody has electronic means to be able to do that. And you get back into the argument about the security of your ballots by electronic media when we talked earlier about having websites and electronic media. So it's not without its problems, but it can be overcome if your documents appropriately address how you can exercise your right to vote, right? So a little bit different, but about the same.
So we talked a little bit about the requirements for amending the documents. Again, you've got to look back to the current documents to see what the provisions say with respect to the percentage of approval that's required for passing those amendments. Generally speaking, master deed and bylaws, again, according to the Condominium Act, you need 2/3 of those co-owners who are eligible to vote. So your documents are going to hopefully identify eligibility to vote, but we're talking about people that are not going to be eligible to vote are those that are delinquent in payment of their assessments as of the voting date. So if it's in a meeting, it's at that meeting. Also talking about people that are in violation of the bylaws. Again, you have to look at your existing documents to see what, if any, the eligibility requirements are for voting. And for condominium associations, again, if the co-owners approve the amendments and there are material changes to those documents as identified in the list of material changes in the Condominium Act, then those amendments have to be approved by 2/3 of the first mortgagees. So again, the co-owners have to affirmatively vote yes for a yes vote to count. If a mortgagee does not return their ballot, that is counted as a yes vote. So those circumstances of what's a yes and what's a no are different between co-owners and the mortgagees. I have never seen an amendment project fail because mortgagees have voted no. I rarely even get any ballots back from mortgagees. I think up to 5 one time in one of my projects. So generally what's going to happen is those mortgagee ballots are going to be sent out, not returned. There's a 90-day window for those mortgagees to cast their ballot. Once that 90 days come and go, then the next step is to get those documents recorded with the Register of Deeds. For the Articles of Incorporation, those amendments will pass if they're approved by a majority of the co-owners who are eligible to vote, unless those existing documents have a different percentage of approval that's required. So if there's nothing stated in your documents about how many people need to approve that amendment to the Articles of Incorporation, the default is the Michigan Nonprofit Corporation Act, which states majority approval is required. Richard, what about homeowners associations?
Homeowner Association, I just want to point out something too. Normally, mortgagees don't respond. Typically, if you get a response from the mortgagee, they'll say, we can't discuss this with you because it violates our mortgager's right of privacy. And I'm going, did you read the letter I sent you? It said this statute says you get to vote. It has nothing to do with your mortgagor, but it doesn't matter. The other big thing about qualified and eligible, I'd like to say if they're delinquent or otherwise been determined to be in violation of any of the restrictions, they're not eligible to vote. Why should we allow them to vote? So that being said, and I like to do that in the condos and in the HOAs. In terms of HOAs, this is one where you have a real problem, and we're going to get into this here. Is there a time restriction regarding the amendments to the documents? Okay. If you find the typical language in the typical subdivision, it'll say this declaration runs for a period of 20 years and it has an evergreen automatic auto renewal provision of every 10 years thereafter until the end of time of the second coming and so on and so forth. All right. So the question becomes now is, can we do an amendment now with say 70% of the people rather than 100% of the people and have it effective now? Well, unfortunately for homeowners associations, there's a case called Brown versus Martin in 2010. And they basically came to the conclusion that these declaration restrictions, covenants running with the land, they're a contract, everybody's relied on it, and you cannot change it unless you get 100% of the people to vote for the amendment. Unless your language is different than the language in the Brown versus Martin case, which I would say a large majority have that kind of language. It doesn't really talk about whether you can utilize alternative percentages. So I've got some communities right now that fortunately enough, their term is going to renew their 10-year term in 2021. So we're working on the revisions now for purposes of having them effective in 2021, because this Court of Appeals case says the amendments you do are not effective until the renewal term, the expiration of the 20-year, the expiration of the 10-year. And that's what, excuse me, that's what I was talking about earlier with reference to when do they become effective. Condo bylaws become effective when they're recorded. Yours become effective when you approve them and in accordance with the amendment provision or upon the expiration of the term that's stated in the amendment provision, right? So there's a couple of cases though, because things come up in terms of there are people that will say, well, I didn't vote for it. I didn't approve it, so therefore I'm not bound by it. The Ardmore Park Subdivision Association case basically clarified that circumstance, going, listen, if there's an amendment provision in there that says 70% of the people can change the way your world goes around, then that's what is going to, that's what's going to control. So unfortunately, whether you liked it, whether you voted for it, whether you didn't even vote, it doesn't matter. If they complied with the amendment requirements, you're bound by it just as much as everyone else. The Conlon versus Upton case is a different twist on that, and that's a circumstance where there was no amendment provision in the documents. And in that regard, then the court said, yeah, you know what, to change all this, you're going to need 100% of the people to change all this, because like we talked about, covenants are carved in stone, they're contracts, they're covenants running with the land, and if you want to change them, you got to make sure you comply with the amendment provision, right? So it's very important for you to discuss with your attorney what are the requirements to amend our documents and when will they take effect. So that has to be gone through. The amendments to the articles must be approved by the majority of the homeowners who are eligible to vote unless the existing documents provide for a higher percentage. A lot of times, basically under the statute, 51% can approve the amendment of the articles. But a lot of times, again, in line with this cookie cutter provision that we talk about, the developer will put in, well, 2/3 of the people got to vote to approve the master deed, and 2/3 of the people got to vote to approve the articles. And you got to have 100% of the people to vote to approve the articles because you need 100% to change the declaration. It's kind of like, no, that's just no. So we want to make sure that we amend the documents to take these kind of, for lack of a better term, silly provisions out and make sure that we make your life livable with the documents that you have. Okay? So.
What if the amendment project vote fails? What do we do now? Well, we've talked about surveys. We've talked about how you can do surveys at any point during the amendment project. If your co-owners did not pass the amendment project, then take a vote or take a survey out to the owners and find out why. Tell us why you voted no. Was it a specific provision? Was it the whole thing? Did you participate in the informational meeting? Tell us what's going on. Have conversations with your neighbors about the project. This is again where the board of directors needs to take ownership of the project. Get out there, board members, and talk to your neighbors. Find out why it didn't pass. Push for more owner involvement. Maybe this is the time that you need to set up a committee for your amendment project. Maybe you didn't have one before. Put a committee together. Don't give up. There are ways to re-energize a community and to get their involvement and tweak those documents so that you are able to get the approval that you needed. I know that one of the other attorneys, my partner Greg Fiorito, had a project that failed. They did a survey, found out what it was about that project that the owners didn't like. They made changes to the documents, sent it around again, and it passed. So it's possible to take a failed project, tweak it, send it back out there and get the votes that you need. But again, it's going to be hard work. The board is going to have to be committed to this project. They need to get out there and collect the votes. Oftentimes projects will fail because not enough people voted. Well, in that case, the board needs to take that time to get out and collect those votes. So it's not the end of the world. We can definitely help you if a project vote fails, but we've had pretty good success rates with our projects because of how we put them together and how we get the co-owners involved and have those informational meetings and get some feedback from the owners. Richard, let's talk about COVID-19. Do we need to run out and amend our documents just because of this pandemic?
You know, I think this is a place for the public service announcement, so that you want to make sure you get involved and get feedback from your owners, but make sure you do proper spacing and distancing and safe measures in that. And since we're on the topic of COVID, and basically amend the bylaws just to deal with COVID, no. First of all, as we've spent the last, I don't even know, almost an hour talking about this, this is not an overnight thing. COVID-19 is an overnight thing. You do need to address circumstances with your clubhouse or your amenities or your pool or anything that you have in terms of having your meetings, a lot of things that you may have to address by adopting rules and regulations to make sure you can continue to function, and given the current pandemic scenario and in the event of any future emergency situation. But if you're already amending your bylaws or starting an amendment project, you certainly want to consider adding language to address language regarding national or state emergencies or casualties or traumatic circumstances. But you don't need to amend your bylaws just to address COVID because it's too long and too tedious of a procedure to try and give you a remedy to take care of things. There's also, we have a Facebook page on rules and regulating amendments during COVID that Tracy and Shane put on before, and there's a site there where you can tune into it and see what kind of rules you can pass and what kind of things you can address to deal on the short-term basis for COVID. But on the long-term basis, yes, I think I put things in my documents with reference to addressing national and state emergencies.
All right, let's wrap things up. What are our takeaways for today's presentation? Dedication. That board has got to be dedicated to this project. This is a marathon. It's not a short distance run. It's going to take a while, as Richard mentioned. This is a lot of work by the attorney, a lot of work by the board of directors to get this project from start to finish. So you've got to be dedicated. You've got to take ownership of this project, not put it all on the attorney. You've got to have communication with the attorney. You've got to have communication with the owners. Always have that informational meeting so that owners have a chance to give feedback to the board. Knowledge. This is, again, you've got to know your community, know what they're going to approve or not approve. So you don't want to try and push something on the owners that you know is not going to get approved. Growth. This is a good opportunity for the community to come together as a whole and help figure out what's best to move forward with your entire community. Protection, proper drafting, enactment, community involvement, all of those things help to protect those that run your association. Again, as Richard mentioned, being on the board is a zero payment job. You are volunteering your time. You need to make sure that you have those protections in place for all those volunteers. Excuse me. And also recognize that the board of directors, we're not going to be able to serve and satisfy everyone. But take this opportunity to compromise and do what the majority of the community needs to move forward with living harmoniously and as happy as we can under the circumstances.
Can I say something there too, Tracy? You know, the thing about taking ownership by the board, you know, it is so important that the board be somewhat unified in this circumstance. If there's something that you know, 3 boards want this, 3 board members don't, try to work on a compromise so that it's presented like, okay, all 5 of us, all 7, all 9, however board members you have, you know, we've worked on this, we've beat each other up on this thing, we've come out what we thought was the best solution to the problems that we have. And it's really important. It does not help the scenario if you've got 1 or 2 board members that start circulating you know, memos saying, well, this is terrible, this is all this kind of stuff. This is a very important undertaking that's going to last 10, 15, 20 years. Hopefully by the time Tracy and I get done with you, other than new statutes that come out that want to change your life entirely, you're not going to have to do this again for quite a while. So it's an expense that's it's well worth, you know, Dunkin' Donuts worth the price. Make sure you get together, do a unified presentment, and get, you know, everybody's entitled to their opinion. I'm not disputing that, but try to make sure you show that everybody's put an effort into this to come up with what they thought was the best solution. Okay.
Well, thank you. We are into the final question and answer period for our presentation this afternoon. I do have 2 final questions unless anyone wants to pop some other questions in chat. Now is your time. So the question is, which party, the attorney's office or the association, is financially responsible for paying for meeting rooms, paper presentations, first class mailings, etc.?
I can jump in and answer that question, and the answer is the association is responsible for all of those costs related to the amendment project. However, if your association doesn't have a property management company, or the property management company needs assistance in getting those mailings out, our office is able to do that for you at an additional cost from the cost of the amendment project. So we do provide those services as an extra fee, but ultimately all the costs of the amendment project lie with the association.
Okay, and the final question is that the co-owners association had opened their pool. It was a nice summer. They didn't have any incidents, but they would like to know if either of you had any experiences or issues with clients opening their pool for this year.
I think for my part, most of our associations did not open the pools, and not necessarily entirely on the advice of counsel, but and a number of considerations. Obviously, there's certain decisions we have to leave to what's called the business judgment rule, exercise of discretion by the board. But there's too much risk of exposure, and we thought it better to say, you know, if you don't have to open it, don't do it. Don't take the chance until we figure out what's going on. And I think I'm not sure. I don't know. Maybe I don't even know if I even had one that opened their amenities this year. Did you have any, Tracy?
I did not. None of my communities opened their pool.
Yeah.
And there are no further questions, so yeah. I will move on.
Just a comment. We opened our pool.
Did you?
Yeah, we we had a set of monitors. People signed up to be monitors. The pool was only open when a monitor was there, and there was a sign-up sheet. When you got to the pool, you had to sign in and sign out the time. So for contact tracing, we had a record of who was there during some point.
So now, did you have spray things and everything for everybody? And did you require masks?
Oh yeah, no masks. You had to be socially distanced on the pool deck. In the water, you didn't have to have it. But yeah, there was spray everywhere. And when you use something, when you left for the person
Now,
who opened the pool had
change,
to spray everything down in the restrooms and
sorry,
all the handles, all the common touch areas.
were the changing room and bathrooms open as well?
Yes.
Oh, okay.
And all that got sprayed down at the beginning of each day and as people used it during the day.
Thank you for your input.
Okay.
Okay. Is that it?
All right, I would just like to thank everyone on behalf of our presenters today and our firm for attending our presentation. If you have any topics that you would like to suggest for a presentation, you can drop them into the chat, or you can send myself or Stacia an email, and we will pass those on to the firm and see what we can get started. If you would like a copy of this presentation, you can email myself at mfrancis@zdfattorneys.com or email Stacia at smiller@zdfattorneys.com. If you have specific questions for Tracy Danner Bond, or you'd like to discuss an amendment project for your community, you can call her at 734-459-0062 or email her at tdannerbond@zdfattorneys.com. If you have questions for Richard Wagner, or you'd like to discuss an amendment project for your community with him, please call 586-465-1330 or email rwagner@zdfattorneys.com. And please mark November 18th, 2020 at noon on your calendar and join us via Facebook Live and Zoom for interviewing and choosing a property manager. You will be able to see Stacia Miller on the other side of the camera in the presenter's seat with another associate, Lee Schofield. So thank you all for attending. If you'd like a copy of the presentation and you are on Zoom, you can feel free to please put it in private chat, your email in private chat to me before you leave. Thank you very much and have a wonderful afternoon.